Stet docket in Maryland. Well, if you've never been to court before, you probably don't have any idea what the Stet docket is, but it's important to know because it's one of the best dispositions you can get in a case. So we're going to tell you the 5 things you should be aware of when dealing with Stets in your Maryland criminal case. Number 1, what is a Stet? Well, Stet is just a weird word for putting something on the inactive docket. That means your case is not going to go forward to trial, but it's also not going to be dismissed. It's like this no man's land. Number 2, how does it work? Well, Stet docket is covered by Maryland rules. Maryland Rule 4248, we're going to put it on the screen, deals with how Stets are supposed to work. Actually, you don't even have to be in court. Your attorney can appear for you, but you need to know what's happening before you agree to do that. Importantly, you need to know that a Stet cannot be granted if you object to it. So you need to talk to your lawyer. You have to agree to Stet to be granted a Stet. Now, how long can a Stet last for? Well, that's up for debate, but there's no specific limit. And essentially, you waive your right to a speedy trial. So you could have a Stet conceivably for a very long period of time. The most common time for Stets are 6 months to a year, but they can be longer. Now you may ask, why does a Stet happen? Why would a prosecutor agree to this? Well, there's a handful of reasons why a prosecutor might agree to a Stet. Maybe their case sucks. Maybe their witness is not very reliable, but they don't really feel comfortable dismissing the case. So it saves them face. They can say, well, don't have any contact with this person and we'll just let it go away, okay? For the benefits of Stet, it's not a conviction. You did not plead guilty, you do not admit guilt. Stet is a perfect disposition for anybody, especially for those facing immigration consequences, because there's no finding of guilt and there's no admission of guilt. The other advantage is, only in rare circumstances can a case be taken from the Stet docket back to the active docket to convict you, and there's a certain time period for that. From the day that your case is stated, either side, prosecutor or defense, can bring it back to trial within 1 year. After 1 year, there has to be good cause shown for it to be put back on the trial docket. This is good for you because after a year, it's going to be very hard for the prosecutor to bring back the charge against you. You don't have to admit guilt and you don't have to risk a trial. This is why most people would take a Stet 7 days a week. Number 5, let's finish up this list, are the drawbacks of a Stet. There are very few drawbacks to a Stet, especially compared to the upside, but let's go through them. You're waiving your right to a speedy trial. You're putting things off, and if you have that year period that we talked about, within that year, they can bring it back for any reason at all, even if they just don't like you. They don't need good cause. So you're waiving your right to speedy trial, and we have seen instances where they bring cases back when they find the evidence they need, and the client's not prepared for that. So you need to make sure you know that you're waiving your speedy trial right. And that's what you need to know about